The Senate Special Committee. Oh, a little loud. Try that again? Okay, good. It's a little better. The Senate Special Committee on Aging will come to order. This is the second hearing of the Special Committee on Aging in the 118th Congress. Senator Braun, thank you for your continued partnership on this committee, as well as all the members. Today we'll discuss a topic of growing national concern, guardianships of older adults and people with disabilities. The data we have suggests that guardianships affect at least 1.3 million people in the United States who have a disability or are an older adult. In many cases, guardianship is a blunt legal tool that transfers all decision-making power about the life of a person to someone else. Guardianship can also put a person at risk for abuse, neglect, and exploitation. In 2018, this committee documented a number of concerns with guardianship in a bipartisan report that called for the following: greater oversight of guardianship, better data collection, and the need to promote alternatives to guardianship. Often people in guardianships need permission to make basic decisions about such matters as their living arrangements, health care, and education. Under some arrangements, a person living under a guardianship must consult with their guardian about voting. Unfortunately, many of our existing systems, such as our schools, healthcare agencies, and even courts, communicate to families that guardianship is the only way to assist their loved ones to make important decisions. However, there are less restrictive alternatives to guardianships that can increase protections for people needing assistance. These less restrictive alternatives enable a person to retain the power to make decisions that affect them and affect their lives directly. Alternative arrangements, such as supported decision-making, can provide people with the support they need to make the decisions for themselves with the support of a team. Today we'll hear from experts and people with lived experience about how these alternative arrangements can help preserve the independence and autonomy of people with disabilities and older adults while ensuring they have the support they need to make key life decisions. For the past 3 weeks, the committee has asked for input about guardianships and their alternatives, specifically about how to improve protections and independence for people with disabilities for people, I should say, who live under guardianships. One individual from Pennsylvania wrote to the committee saying, and I'm quoting, "The system is a sad commentary on how we treat our elderly, and in a word, the system is disgusting," unquote. That's the view of one Pennsylvanian. So I want to thank everyone for that kind of input that we've heard from many different quarters, and for them taking the time to provide that kind of feedback. So without objection, I offer their statements for the record, and these are the statements, 312 statements from 40 states and territories. You can see it's a pretty heavy volume of statements. So I appreciate those who shared their troubling experiences with fraud and exploitation, as well as those who offered ideas about how to promote alternatives to guardianships while protecting the rights of individuals. Many of the experiences that people shared contributed to the development of my new bill, the Guardianship Bill of Rights Act, which will be introduced today. We know that guardianship is a complex and personal issue. It's clear that we need guardrails to protect the rights of people in protective arrangements. This Guardianship Bill of Rights Act will ensure that the civil rights of older Americans and people with disabilities are protected and that alternatives to guardianships are, in fact, promoted. So I look forward to hearing from our witnesses. We're thankful for their presence and their testimony, the experience and expertise they bring to us, And with that, I'll turn to Ranking Member Braun for his opening remarks.
Thank you, Chairman. There are far too many difficult and painful stories of guardianship abuse, often from people who did not require a guardianship in the first place. No American should have their rights unnecessarily stripped from them. Harrowing tales were sent to this committee of rights being taken away by a single stroke of a pen in the name of guardianship. There are a number of Hoosiers who shared their personal experiences with me. I thank you all for submitting your statements. Gave me a lot to go on in terms of what we need to emphasize here in this hearing. Heard from the sister of Navy veteran Jimmy Johnston, who said that a court-ordered guardianship ultimately led to her brother's death. While she had been designated his health care surrogate, the professional guardian was appointed to make life or death medical decisions for Jimmy without prior medical knowledge or family history. After Jimmy's death, his family received a hospital bill of nearly $1.2 million. $1.2 million. Nearly all of it was billed to Medicare. That's unacceptable. Guardianship is supposed to mean protection, not that. When done correctly, it's a valuable tool to protect vulnerable people. But as so many stories have shown us, it can also lead to exploitation and abuse. We must empower states with the tools and resources they need to protect and empower their most vulnerable residents. Indiana has been an innovative laboratory on guardianship in recent years. It created a guardianship registry to improve data. 2019, Indiana passed a supported decision-making law to expand options for people who need a protective arrangement. This gives Hoosiers in need the chance to pick support that works best for them. And when we do this state by state, we're using the laboratories in this country in terms of how to do it best across the country. Indiana's Volunteer Advocates for Seniors or Incapacitated Adults program connects volunteer guardians focused on personal autonomy to Hoosiers without support or protection. These volunteers step in when they get calls from adult protective services, nursing homes, or even banks alerting them to an incapacitated person who has no one else to look after their affairs. Sarah Walker is the director of Southern Indiana Adult Guardianship Services. She is a self-described old soul who traces her love of working with older adults to her love for her own grandparents. Sarah and her team work across 5 counties in small-town USA to help Hoosiers be as independent as possible. They assisted one client struggling with drug use to find help and a better living arrangement. Now they are working to restore her rights. Hoosiers continue to show us how states can solve these issues. The Adult Guardianship Office is managing these innovative services. It works with the courts and stakeholders to find practical solutions for local issues in the guardianship system. Our role is to remove barriers in states' ways, not add to them. I am introducing the Guardianship Grant Flexibility Act with Chairman Casey to remove barriers by making federal guardianship grants more flexible. This bill would allow states to recruit and train law students to represent respondents in guardianship cases and to serve as guardians ad litem. Law students interested in protecting the rights of older adults should not be held back by arbitrary federal interference. This is a common sense reform to give states more tools to protect people in need. I ask unanimous consent to enter into the record a letter of support for this bill by the Elder Justice Coalition.
Without objection.
I look forward to hearing more about common sense steps we can take to strike the right balance between protection and freedom. And I look forward to hearing how states can learn more from each other on the issue. I yield back.
Thank you, Ranking Member Braun. Our first witness today is Dr. Tina Payon. Dr. Payon is a professor in the Department of Educational Counseling and Leadership at Monmouth University. She's also a licensed counselor and a resident of my home state of Pennsylvania. Dr. Payon has personal experience with the guardianship system when her mother was placed in a guardianship following a stroke in 2015. Thank you, Dr. Payon, for sharing your expertise and experience with us today. Next, I'll introduce our second witness, Mr. Ryan King. Today, Ryan is accompanied by his mother, Susie. Ryan works with several organizations, including Quality Trust and Project Action, to advocate for guardianship reform. He was in a guardianship for 13 years before becoming the first person in Washington, D.C. to have their guardianship terminated in favor of supported decision-making. So, Ryan, thank you for being with us today and for sharing your story and your expertise with the committee. Now I'll turn to Ranking Member Braun to introduce our third witness.
Thank you. I'm going to introduce Nick Parker. He is the staff attorney for Indiana's Adult Guardianship Office. Nick oversees Indiana's Volunteer Advocates for Seniors or Incapacitated Adults program, the Guardianship Registry, and the Adult Guardianship Symposium. He engages with practitioners, experts, and stakeholders to improve Indiana's guardianship system. He also spearheads efforts across the Hoosier State to promote alternatives like supported decision-making. Nick is a graduate of IU's Maurer School of Law. He previously worked for Indiana Legal Services Medical Legal Partnership. He also has direct experience representing clients in guardianship cases and in securing supported decision-making. Welcome, Nick.
Thank you, Ranking Member Braun. Our final witness, fourth and final witness, is Dr. Carrie Sjogren. Dr. Sjogren is the director of the Kansas University Center on Developmental Disabilities, senior scientist at the Shufflebush Lifespan Institute, and a professor in the Department of Special Education at Kansas University. Her research focuses on assessment and intervention in self-determination and supported decision-making for people with disabilities. She's an expert in less restrictive alternatives to guardianship. Dr. Sjogren, thank you for being here. So we'll start with our first witness and her testimony. Dr. Payon, you may begin your testimony.
Good morning, Chairman Casey, Ranking Member Braun, and members of the Special Senate Committee. I am a university professor and a licensed professional counselor. I live just outside of Philadelphia in Montgomery County, Pennsylvania. I am here to share my family's story. It is a story that resonates with so many other families. In January 2015, my 68-year-old mother had a major stroke. A judge granted guardianship to myself and my brother. The judge also ordered a court-appointed attorney as well as another evaluation by a court-appointed psychologist. At that point, 2 professionals declared my mother incapacitated. So much to our surprise, the newly appointed attorney insisted on a 3rd evaluation. It resulted in the same conclusion, but now to the cost of my mother's state of over $8,000. This was the first indication that something was wrong with the guardianship system. Soon after, the inventory of the estate was filed, which valued my mother's estate at a little over $2 million, including the business she owned. My brother and I successfully performed guardianship duties for almost a year. Regardless, the court-appointed attorney insisted on a new plenary guardian, a lawyer who admitted she had no previous experience working with large estates, businesses, or families who were actively involved. This was the second indication that something was wrong with the guardianship system. In 2018, my mother's assisted living facility told us they had not been paid in months. Despite more than adequate funds available, our mother was in arrears for close to $100,000 to her facility and care aides. When we threatened to expose this situation to the courts, the guardian resigned. But she only resigned as guardian of the person, not guardian of the estate. We quickly learned that this was a decision that was supported and encouraged by the court-appointed attorney. This was very concerning to us and indicative of a much larger problem. My brother and I kept expressing concerns, but we had no voice. Eventually, in 2022, our mother's guardian informed us that our mother's business would be sold, eliminating half of the monthly income she relied on for her care. Even worse, real estate taxes went unpaid. My mom never paid a bill late in her entire life, and now late fees and penalties piled up in excess of $11,000 due to the negligence of the guardian. This was a person charged with ensuring my mom's well-being, and yet she intentionally sold the business, my mother's largest asset and income source, and she failed to protect her second largest asset, her home. It was only when we approached the court-appointed attorney to request the removal of the guardian that the bills got paid. Finally, the guardian of the estate agreed to resign. Shortly after, the court-appointed attorney agreed to resign with conditions. My brother and I cannot contact any governmental, regulatory, or administrative office to make claims or allegations of her wrongdoings. We cannot speak to family or friends about her negative impacts. Either action would be deemed a violation and would result in monetary and possible removal as our mother's current guardians. If we had agreed to this gag order, I would not be here today. And yet, we fear vindictive repercussions as a result of my testimony today. Since her stroke, this situation has cost my mother more than $116,000. That is money that could have been spent on her care, but instead went to fund a system that seems driven to pay professional guardians, attorneys, and others motivated by greed and power. My situation is not isolated. In my experience, when an incapacitated person has a larger estate, they are more likely to have frequent involvement with the courts, which increases payments to lawyers, guardians, and services hired by these guardians. Even more disturbing, the same individuals are selected repeatedly to serve in these roles, creating conflicts of interest and perpetuating a widespread abuse of power that impacts this marginalized population. As I sit here today, my mother's situation remains unresolved. I call on you, our senators, to create change. You have the ability to implement meaningful reform. From my perspective, we need federal standards that regulate the appointment and oversight of judges, court-appointed attorneys, and court-appointed guardians. Additionally, families like mine must have a recourse to prevent devastating medical and financial exploitation. On paper, the current system appears well-intentioned. That is not how it plays out. On behalf of my family and so many others, I beg you to please implement meaningful reform. Thank you.
Dr. Payon, thank you for providing your testimony and bringing your mother's story to this hearing today. Our next witness is Mr. Ryan King. And Ryan, we're going to play your video testimony, video statement that we'll play right now.
Good morning, everyone. My name is Ryan H. King. I live in Washington, D.C. I have disabilities. And I am independent. I was under guardianship for 13 years, but not anymore. I can do many things on my own, but sometimes I need help. I cook 3 days a week. With hold on, support. Wash my wash clothes and do dishes. Take out the trash on. Go to the movies. Go to WWE events, wrestling matches, and travel. I work at Safeway come October at what? It will be 23 years as a courtesy clerk. I love washing.
What I do.
Oh, what I do, yeah.
Metro.
Oh, what, Metro? Oh, Metro Access, right? Yeah. What? Metro Access Transportation Services takes me to work. In 2003, I graduated from high school and wanted to own a limousine business. To get started, on my business, I have to go to the government agency for help. My parents were told they had to get guardianship for me if I wanted to go get things, their services. Why? I was already independent with support for the things that I wanted to do. I can make choices. Right here? No.
I didn't above it.
I didn't like being under guardianship because I had wait a minute. Hold on. Okay, I had to go to court. No one. I'm kind of stuck.
I had to go to court.
I did not get to.
I had to let them know.
Everything I did.
Yeah.
Like going to events, doctor's appointments, and church. No one else in my family did that. In 2007, my parents went to court to end guardianship. The court gave me a lawyer. The lawyer said I needed
to stay.
to stay under guardianship. The judge agreed. I did not win my case. I read about Jenny Hatch in the paper. Jenny Hatch was the first person to win.
You use.
What?
To use. U-S-E.
To no. Oh,
To
use support decision making.
To
Make
to end.
to
Okay.
to end her guardianship. Quality trust.
Mm-hmm.
What?
That's right. Trust.
Trust for
Individual.
individuals with disabilities. Help her. I'm going too fast. Yeah, I got them to help me tell the court about the things I can. Oh yeah, things I can do. They use supporting decision making to show what I could do, and all the people who help me, my family, my friends, and programs I am in. I did that. I did all that.
Okay, a part of my team.
A part of my
Team. Right?
team. I am in Project Action for Advocacy, Lifelong Partners, and
For
spiritual and activities, and quality trust for leadership and advocacy support. We went back to court in 2016. I told the judge said he read about everything.
Everything
I can do. He was impressed. Ending guardianship. I won. I know I can do some things. What? What?
Take your time. Some things
by myself.
I know. So take your time.
Okay.
I know.
I need help. Sometimes. Everybody needs help. Sometimes. I tell people not to judge me before you know.
Mr. King, thanks for your testimony. Yours is a story of inspiration, and we need to hear that. And we're grateful you're here. And Mr. Parker, you're next. Thank you.
Thank you, Chairman Casey, Ranking Member Braun, members of the committee. My name is Nick Parker, and I'm the staff attorney for the Adult Guardianship Office with the Indiana Supreme Court. My office serves as a resource for courts, members of the public, judicial staff, and grantees to receive quality information on the guardianship process and tools to maintain a functioning and effective system overall. Before starting with the court, I was a staff attorney with Indiana Legal Services. In this role, I worked directly with clients, addressing decision-making needs with them and their families, including guardianship, but often also including termination and supported decision-making. My interest in caretaker issues started when I was in the 4th grade, watching my mother care for my grandfather while balancing 2 nursing jobs and raising her own family. Her goal was to allow him to live as independently as possible for as long as possible. She never served as his legal guardian, but was his primary caretaker for many years. I know that not all seniors were as fortunate as my grandfather to have my mom, and to this day I understand the importance of having strong programs and supports to help those that need it most and to help them live independently. My office funds and supports 20 volunteer programs called Volunteer Advocates for Seniors and Incapacitated Adults. These programs work on the local level with county courts to address the needs of people in their communities who require guardianship services but do not have suitable friends or family to take on that role. These programs cover 52 Indiana counties and adhere to both Indiana law and National Guardianship Association standards of practice. We have strict ethical requirements in place about staff to volunteer ratios and reasonable caseloads for these programs. My office also oversees court technology, including a guardianship registry for local courts. This is an online system to verify guardianship information. It serves both the public database function and a behind-the-scenes case organization feature. This registry is so important because it provides timely and important data on guardianships and promotes uniformity and entry of guardianship cases in our e-filing system. Judges and others across the state can use this registry to ensure safety of protected persons through access to contact information and demographics. Banks and financial entities can also check our registry to confirm a guardianship, and it does keep track of cases that have been terminated. The Adult Guardianship Office was a crucial part of a grassroots task force to address supported decision-making and less restrictive alternatives in our state. This task force showed the power of local organizations working together to effectuate state-level change. In 2019, Indiana became one of the first states to recognize supported decision-making as a state law. This new law also created a requirement for courts to consider less restrictive alternatives before ruling on a guardianship petition. Since then, my office has been working on ways to implement ideas for guardianship innovation, often in the absence of direct funding. This includes a proposed guardianship educational system modeled after a program in Ohio, which we hope to launch as a pilot program to help courts ensure that guardians are given proper introductory and ongoing education about their roles and duties. We are also considering a law school clinic program that would link supervised students to local courts to serve as direct advocates or guardians ad litem. The GAL process in Indiana ensures that the best interests of a person at risk of guardianship is served and that appropriate levels of decision-making support, including supported decision-making, could be put in place. Guardians ad litem can investigate less restrictive alternatives and ensure compliance with state law and promising practices. For counties and communities that might traditionally have a hard time recruiting suitable GAL candidates, a law student clinic could provide the necessary staffing for this process to be a success. The Indiana courts have the proven ability to convene multiple stakeholders and bring organizations and entities together to address problems head-on. Indiana has strong support and commitment from our Chief Justice, Loretta Rush, which will allow our Adult Guardianship Office to serve its traditional functions as well as expand its outreach in new areas in the coming years. Though there is room for improvement in Indiana, we have a strong working network of guardianship stakeholders that are willing and able to tackle issues that come up in our state. Grassroots organizing and local input have been successful in the past, and we hope that similar working groups will help implement changes and improvements uniquely suited to the needs of our communities. I look forward to discussing the strengths and experiences of our state with others today, and I hope to share thoughts for the future of guardianship programming and innovations that are needed. Thank you.
Mr. Parker, thanks very much. Thanks for bringing Indiana's story to the committee. Dr. Sjogren, you're next. Thank you.
Thank you, Chairman Casey, Ranking Member Braun, and members of the committee for the opportunity to testify on the importance of alternatives to guardianship for people with disabilities, including people with intellectual and developmental disabilities and older adults. My name is Carrie Sjogren. I am a professor and the director of the Kansas University Center on Developmental Disabilities. My research over the past 20 years has sought to advance self-determination of people with disabilities. And there is clear evidence that we can provide alternatives to guardianship that preserve rights, enhance self-determination, and support the intent of disability civil rights laws, such as the Americans with Disabilities Act, which states in its findings that physical and mental disabilities in no way diminish a person's right to fully participate in all aspects of society, but that people with physical or mental disabilities are frequently precluded from doing so because of prejudice, antiquated attitudes, or the failure to remove societal and institutional barriers. As Senator Casey noted in his remarks, it's estimated, although we're in critical need of better national data, that 1.3 million adults with disabilities and older adults are under guardianship arrangements that limit their legal capacity to make decisions about their lives. Being under a guardianship arrangement can take away rights to make legal decisions, relationship decisions, reproductive decisions, financial decisions, health and medical decisions, education decisions, decisions about where to live, employment decisions, as well as rights to vote and be involved in civic life, to travel freely, and to be involved in other daily life decisions. There is a general consensus that in practice, guardianship remains a default for many people with disabilities and older adults who need supports with decision-making. There is limited and inconsistent access to and understanding of less restrictive alternatives like supported decision-making. This is despite people with disabilities and organizations, including the National Guardianship Association, asserting that guardianship should only be considered after alternatives to guardianship have been proven ineffective or are unavailable. Defaulting to guardianship without considering alternatives sustains societal and institutional barriers. Current research, advocacy, and lived experience has shown us that people with disabilities can make decisions in their communities and access the supports they need to do so. None of us would want our rights or the rights of our family members or loved ones to be taken away if there were other alternatives. So what can we do to change the options available to people with disabilities, older adults, and their families? We can change the default and provide access to alternatives. For example, supported decision-making as an alternative to guardianship can be understood as the process whereby a person with a disability or an older adult is enabled to make and communicate decisions with respect to personal, financial, and legal matters on an equal basis with others without disabilities. Supported decision-making does not remove decision-making rights. It builds a system of support. For example, if a person needs support with medical decision-making, they can identify the person, technology, or other decision aid that can best support them in understanding and communicating their decisions. They can identify a different person or resource for financial decisions or for any life domain they need support with. And these supports can be changed over time as support needs and as decision needs change. This is aligned with how we all use supports to make decisions in our communities. We all get information and advice from people we trust in a way that we can understand it to help us make the decisions we need to. To advance protection and empowerment in guardianship and its alternatives, the goal of today's hearing, I offer the following recommendations rooted in research and the voices of people with disabilities and older adults. First, establish a clear, consistent definition of supported decision-making and guidelines for its use. Second, advance education, training, and outreach on supported decision-making and alternatives to guardianship across the multiple systems, such as education, legal, health, disability, financial, and aging, that impact decision-making rights. Third, adopt recommendations by the National Guardianship Association and other organizations that guardianship be the protective arrangement of last resort. Fourth, ensure protections for the civil rights of people with disabilities and older adults who are being considered for or are under guardianship arrangements. Fifth, establish data collection systems that allow for a clear picture of the use and outcomes of guardianship, supported decision-making, and other protective arrangements and alternatives. To close, there are existing research-based tools and programs to enable supported decision-making. Courts and state statutes are increasingly recognizing supported decision-making and other alternatives to guardianship. We are learning that supported decision-making is feasible to implement, that people feel more supported and able to make decisions, and that establishing a network of trusted supporters can reduce risk. Further, we know that more opportunities to make decisions is linked with other important outcomes, including health and well-being, accessing preferred living arrangements, and living a self-determined life. It is an opportune time to remove societal and institutional barriers to supported decision-making and alternatives to guardianship, using research and the lived experience of people with disabilities to enhance protection and empowerment. Thank you for the opportunity to be here today.
Doctor, thanks very much. As many of you know, at our hearings, especially on Thursdays, senators are in and out of this hearing and other hearings and meetings. So I wanted to make note of those who have been here or some may be asking questions, some may not. But Senator Rick Scott of Florida has been part of our hearing, Senator Gillibrand of New York. And I will cede my question time to Senator Blumenthal of Connecticut. Senator Blumenthal?
Thank you so much, Mr. Chairman. Thank you and the ranking member for having this hearing. I'm sure as everybody in this hearing room knows, Senator Casey has been a champion. That word is often used in the United States Senate, but he has been a true champion of the interests and values that you are here to represent. And not just in words, but in the legislation that he's advanced to provide, for example, more compensation, more care for the caregivers. And we're talking here about guardianship, people who care for other people. Nothing is more important in our society than that kind of caregiving. Guardianship, it's a legal term. I'm a lawyer. I know what it means in the abstract, but you know what it means in the day-to-day performance of that trust responsibility. So I want to thank everybody who is here, both at the witness table and in the audience, for your caring about this issue. In Connecticut, the probate courts receive 600 new petitions for guardianship of adults with intellectual disabilities every year. At the same time, reported rates of elder abuse are rising in Connecticut and across the country. This abuse is intolerable. I fought it when I was Attorney General of Connecticut, and I'm proud to say that I've worked with Senator Casey and others in the Senate to fight it here. This abuse can take many forms, as you know, including financial exploitation, emotional and physical abuse, and we need to do more to protect it, as we have started to do in 2017, passing the Elder Abuse Prevention and Prosecution Act. I was proud to work on that measure. It authorizes certain court-appointed guardianship oversight activities under the Adult Protective Services Demonstration Grant Program, and we need to appropriate the money that's necessary to implement it, as well as to investigate through the Department of Justice the kinds of abuse that have been mentioned here. I want to ask Dr. Sjogren, in your testimony, you mentioned the variety of terminology to describe guardianship arrangements, which sometimes limits our understanding of the circumstances that lead to the outcome of such arrangements. And you offered that a guardianship is a legal arrangement under which an adult's decision-making authority is granted to another person based on a determination of impaired decision-making capacity. But this determination doesn't require consideration of less restrictive kinds of alternatives, such as supported decision-making. Do you think implementing a national definition, a model definition and standards such as you've described today, would aid in combating elder abuse? And obviously, states bear a major responsibility here. Do you think it would provide guidance to states and be a positive development?
Yes, thank you for that question. And yes, I do think so. I think establishing a foundation for the definition, the standards for implementation is critically important. as you noted, we have very little clarity even on how many states are implementing supported decision-making arrangements in the same ways because of that lack of consistency. So having a base level of understanding of what we're talking about and talking about supported decision-making, how agreements are set up, and how protections will be put in place is very important to provide that base level of understanding of what we're talking about and to allow data to be collected to inform our understanding.
Thank you. Dr. Peo and I have been very disturbed about your description of what you went through, what your family have experienced in your attempts to ensure your mother's well-being. Your family situation describes a system where the courts, professional guardians, psychologists, healthcare providers, and others seem to be connected and have an interest in charging estates for their services. And you said that we need to provide a recourse for families who experience medical and financial exploitation to prevent their future exploitations. I totally agree. And I'm wondering if you could tell us whether you think a dedicated advisory board would be helpful to facilitate progress in combating this kind of abuse.
Thank you for the question. Yes, I believe that an advisory board would be helpful as we determine these types of abuse. I also believe that having systems or recourse in place for families, similar to that of Elderline or Childline, where professionals are reported if they are exploiting the elderly. At this point, that is not what those national hotlines are for. They will send you back to the courts, which are part of the system that I have found my own problems with. As far as a counsel, as long as it was an equitable counsel that took into consideration the background of the individuals who sit on a council, I think it would be very effective. Hearing voices from families who have experienced this exploitation may be helpful as members of this council.
I thank you very much. Thank you again to the experts who are here and the champions and advocates, and thank you, Mr. Chairman, for yielding your time. Thank you.
Thank you, Senator Blumenthal. We'll turn next to Ranking Member Braun.
Thank you. First question will be for Mr. Parker and Dr. Sjogren. On supported decision-making, again, each in your own ways, tell me what's important. I believe that freedom and choice are, so important in any of this. And Indiana's 2019 supported decision-making law opened new opportunities for protection while allowing for more individual choice and freedom. So each of you tell me why it's so important. We'll start with you, Mr. Parker.
Thank you, Senator. The 2019 law change in Indiana was really groundbreaking because it was just like a next step in person-centered planning. So I was excited to have been part of that task force that got that accomplished for our state. The law created a new paradigm for how courts view a guardianship petition and review. So what it did is it showed that there have to be efforts to have used something else or considered it before guardianship's granted. Before 2019, that was not necessarily the case. So this shifted the dialogue from guardianship as kind of a binary system of help versus no help, and it turned it into a last resort system, so that if somebody has other resources or supports available, they're to try those and to make sure that if those aren't available, that's the only way that guardianship moves forward. As a practitioner, I helped clients with supported decision-making, so we were either taking pre-existing cases and trying to find less restrictive alternatives after 2019, or more often we were talking about alternatives before any petition was filed. And first, I could see my clients just being able to take control of their case and take control of that conversation. It was a huge shift. But also, many people who otherwise would have maybe served as guardians before 2019, they were more than willing to pursue less restrictive alternatives. In fact, many didn't even realize there were other options. So the 2019 law gave us education, but it also gave us a new way to look at these cases. And though there's still work to be done, I think this is a resource, and my office links people to resources. So supported decision-making being a part of our law really allows us to be focused on independence and what people can do rather than a restriction under a guardianship.
Dr. Sjogren.
Thanks for the question, and I agree with everything that Mr. Parker just said, and I'll build on that in terms of the importance that I believe it was Senator Casey that said in his opening remarks that guardianship is often used as a blunt legal tool. And that's not how most people interact with making decisions in their day-to-day lives about multiple domains of life. Using a blunt tool to address the range of decisions that have to be made, the range of support needs that people have, doesn't allow us to individualize, doesn't allow us to deal with the realities of people living and interacting in their community. As we heard from Mr. King, he talks about how we all need supports in some areas of our lives, but we should have the right to choose those supporters, to access those resources, and still be driving the decision-making. Supported decision-making presumes competence. It presumes the ability to make decisions and really requires us to disprove that before moving on to least restrictive alternatives.
Thank you. Mr. Parker, yes, Indiana's done some things I think that have kind of been trailblazing, so to speak. Let's look at the guardianship registry. This system makes information about guardianship more transparent. Other states have adopted similar changes. Why are the states, you think, best positioned to handle guardianship issues, and how are they learning from each other's policies?
Thank you, Senator Braun, for that question. I started with the courts a year ago last week, and I was just amazed at how quickly states were contacting me to talk. Since that time, I've met with 15 other states and all over the country. There are groups like the National Center for State Courts that can help make connections with states, and then there's a lot of conferences and trainings out there. So people in my position with different states are talking to each other. They're doing that in kind of two ways. It's geographic. We're meeting with other Midwest states and looking at what they're doing. And then sometimes it's based on how courts are structured. So Indiana has a strong amount of local control called a non-unified court system. So I've been meeting with other states like that. Sometimes courts will kind of meet based on factors like whether they have supported decision-making yet in their state law or what they want out of innovations such as technology like the guardianship registry you mentioned. So what I'm seeing in my first year is that there's clear commonalities that less restrictive alternatives are positive changes, keeping guardianship as last resort, and an emphasis on education and the use of technology. But outside of that, there's not really a lot of consensus on what we should do because everyone's trying something slightly different right now. I call this kind of the innovation stage. We're looking at like picking and choosing what might work for our state, what might not work for our state, and what have other states learned and done. So right now, if we picked a set of rules for everyone to go with, it might disrupt some of these discussions and it might have good ideas go unnoticed, frankly. So there's not a one-size-fits-all solution for guardianship, but I do think states are best equipped to address the needs of their communities and find these solutions, and both inside their state or from other states that they're talking with. Community-level partnerships have worked for Indiana in the past, and I think that states will drive those effective changes and innovations in the future.
Thank you. I'll have a couple other questions. I'll save that for a second round.
Thank you, Ranking Member Braun, and I'll take my question time now. Dr. Payon, I'll start with you. As you highlighted in your testimony, your mother's stroke necessitated a guardianship due to her being incapacitated. However, your story emphasized the critical need for these guardrails that we spoke of earlier, guardrails to ensure that even while in guardianships, individuals and their basic rights are protected. The bill that I'm introducing today, the Guardianship Bill of Rights Act, will direct the Attorney General to create standards for protecting the civil rights of people living under guardianships. Can you describe how legislation like this would be helpful, especially in the context of your own family's experience with your mom?
Yes. The legislation, after I read it, there are 4 points that I find would be very helpful, or would have been very helpful. An alternative arrangement for my mother would have been helpful. Family members are less restrictive than court-appointed personnel and cost incapacitated people $0. A guaranteed procedure for the modification or discontinuation of restrictive protective arrangements would have been helpful. Regular and consistent background checks on court-appointed personnel would have been helpful. And finally, the ability to report and investigate abuse of guardianship would have been helpful. So all 4 points of the legislation would be helpful moving forward.
Well, your own story gives us a foundation for legislation like that, and I'm grateful that you're willing to talk about it and bring that to the committee. I'll move next to Mr. King. We heard in your recorded statement, Ryan, that you have, and we know from your story that you have multiple disabilities, but you're very capable of making your own decisions, decisions that you make with support. And I was looking at the written version of your statement, which is basically exactly the same as what you did by way of video. And you said in the first line, "I have disabilities and I am independent." Kind of sums it all up in one sentence. I have disabilities and I am independent. And then right after that, in the next paragraph, you say, quote, "I can do many things on my own, but sometimes I need help." That would apply to me too, and most of us, all of us really. But this idea of independence and making sure that we're not just aware of that as a concept, but that we're putting in place policy that would effectuate it is critically important. The process of supported decision-making relies on family and friends to create a team to support you. We have a number of states that have addressed this. Pennsylvania, the state I represent, currently has a grant to help families, courts, and other entities address, or I should say understand, how to implement supported decision-making in order to both protect people who need help making decisions and to ensure that their rights are in fact honored. While not a new procedure, it seems that supported decision-making and other arrangements that are less restrictive than guardianship are not that well known, even, frankly, by people who should know in our system, in government. So I ask you, Mr. King, how did you put in place the supports that you needed while you're developing your supported decision-making arrangements?
First of all, I know that everybody needs to be aware of everything, because if you're not aware of everything, then you're lost. You're lost in the sauce. And people need to know. If people don't want to be under guardianship, they don't have to be. Do you hear me?
Mm-hmm. Yep. Well said. That about sums it all up. Now, because we have senators that have busy schedules in and out, I was going to go a little longer to kind of give us some more time, but Senator Vance is here, so he'll be next.
Great, thank you, Mr. Chair and Mr. Ranking Member. Mr. Parker, I want to start with you, and I'm obviously a little biased here, but I understand the Ohio model has a lot to recommend it in terms of addressing some of these guardianship issues. What specifically about the Ohio model do you think could serve as a model for other legislation in other states or here federally?
Thank you, Senator. When I first started with the court last year, I almost immediately met with Ohio. It was a little easy for me to do. I'm from Ohio, but moved to Indiana.
Sure.
What I was really fascinated with Ohio is that they have a system of guardian education set up. And I really think it's a great system because it allows for local communities to submit trainings to have on an online database. And it allows people to kind of watch those at their leisure, guardians and others, but they have to take those credits. So when a court orders a guardianship, they, as I understand it, have a system where they take certain amounts of ongoing education about their roles. I really saw for Indiana that this could be a model to have trainings on there about less restrictive alternatives, but also about financial management and other things that go into the day-to-day of a guardianship. So I think Ohio could serve as a model for other states that don't have an education system, because Not all states have one, and Ohio's done it very effectively. So that's what I'm talking about with the state kind of coalitions and learning from each other. I took that back to my role, and I requested something like that in a federal grant. We unfortunately didn't get the grant, but we're looking into implementation of a system like that, and I look forward to speaking with my counterpart in your state very soon.
Sure. Thank you. And you know, I guess one just basic factual question of the current guardianship situation that we have in our country. Do we have a good sense of how many of those are family guardians versus, you know, some sort of professional guardian?
So in general, counting guardianships is incredibly difficult
Sure.
because of a lot of different challenges, not only with finding cases that might have predated court technology like registries, but also just generally because it's a fluid arrangement that can change. And sometimes people will have a guardianship terminated only to possibly have it reinstated at a later date. So for those and many other reasons that have been stated here today, it is difficult to count adequate guardianship numbers, but I do think states like Indiana have created a good guardianship registry that integrates directly with county courts to help with that. I think counting is the first step, and then the second step is looking at review of those cases and saying this might have been a case where guardianship was granted.
What's a good guess in Indiana for how many are family guardians versus non-family?
So I unfortunately don't have that data, but
Sure.
I can look into it. We have a court technology team that I could try to get some numbers for the.
Yeah. We'll follow up maybe off the record and just try to understand a little bit better. And the reason that I ask here is, you know, for obvious reasons, you might expect a family guardian to take the responsibility a little bit differently than a professional guardian, and you know, not to implicate or cast any judgment on professional guardians. I'm sure many of them do a very, very good job. But as the country gets older and as fewer and fewer people have children, what I do worry about a little bit, of course, is that you have this growing class of professional guardians who maybe don't have the same interests, the same emotional attachments to their loved ones, and you know, that's obviously something we're going to have to think about here. And I know that we're all very focused on. I know I'm running short on time here, so let me just close before I yield here. You know, Dr. Paoni, am I pronouncing it right? Paon. You know, your story was very illuminating to me, and I know I want to echo Senator Casey. I know it took a lot of courage to share it, but I appreciate it. I'm sorry it happened, but I appreciate your willingness to actually illuminate this committee. It helps us as we figure out what to do. Mr. King, I want to appreciate, offer my gratitude to you for being here and offering your insights. And Mr. Chagrin, Dr. Chagrin and Mr. Parker, thank you both for being here as well. Thank you. I yield.
Thank you, Senator Vance. We will now move to a second round of questions. I'll start, and then I'll turn to Ranking Member Braun. I wanted to get back to this question of supported decision-making, and although we don't have anywhere near the adequate data that we need, the Council of State Legislatures estimates that there are about, as we said earlier, 1.3 million people under guardianships across the country, but we have to bolster that with additional data. We know that many of these are not working well, that's obvious, but there are hundreds of instances of abuse, neglect, and exploitation of people under guardianship arrangements. We also know that guardianship removes the rights of people to make their own decisions, such as where to live and with whom to interact. So I'd ask this of a number of our witnesses: what's the benefit of making guardianship a choice of last resort? It seems like in our system today, it's become the first resort, or what courts and others turn to immediately. How do we make that the guardianships the choice of last resort, and make alternatives like supported decision-making the default position instead of the other way around? Anyone who wants to answer, but maybe I'll start with Dr. Paon.
Alternative arrangements would allow willing and able family members to care for their loved ones, supporting, in my case, incapacitated person with decisions that are aligned with the wishes that she had prior to incapacitation. So alternative arrangements would be ideal as opposed to guardianship.
Mm-hmm. Anyone else? Oh, Dr. Sjogren?
Yeah, I'll just add that really, I think, essential to make this a reality, to flip that default, really is defining and having clear standards and guidelines. I do think that the points that have been raised, especially about looking at variation across states, looking at variation in implementation, can provide useful data, but we need a baseline standard to make sure that everyone has access to these less restrictive options. I think it's also really important to think about education, outreach, and training on supported decision-making and other alternatives. There really are multiple systems. For example, we talk about pipelines to guardianship. For example, the National Council on Disability has talked about the school to guardianship pipeline, whereas students are transitioning from their kindergarten through 12th grade public education, families are being told about guardianship at that transfer of the age of majority. And again, it's viewed as the default option instead of building resources and supports for supported decision-making. And that's largely because people aren't aware of and have access to the education and training on these options that have been talked about, both inside of systems as well as empowering families and people with disabilities to access these options.
Mr. Parker, I know you've had to wrestle with the legal and policy implications of this. What advice do you have for how do we flip the, in essence, flip the default to supported decision-making?
So I think some states do have a structural guardianship as last resort built into their law. So I'm fortunate to be in a state where, because of the protections and the things that are required in a petition for guardianship, that it is a last resort. I think the next steps, though, in working with that paradigm are education about these less restrictive alternatives, and just to echo what everyone has said on the panel today. But I would also say review and empowering courts to have review of guardianship is very important. And I'm looking forward to going back to my state and working with courts to implement review processes in line with national standards with the National Center for State Courts.
Well, Ryan King, I noticed in your testimony that you were not willing to accept the default of guardianship, but you had to take two cracks at it, right? You said towards the end of the first page of your testimony, you said the lawyer, and I'm quoting you here, the lawyer said I needed to stay under guardianship. The judge agreed. I did not win my case. But then later, when you read about Jenny Hatch and her story, the first person to use supported decision-making, and then towards, obviously, at the very end of your statement, you say that we went back to court in 2016. The judge said he read about everything I can do, again, emphasizing your independence. Then you go on to say he was ending guardianship. I won. That was a good win. I won. I know I can do some things by myself. I know I need help sometimes. Everybody needs help sometimes. So you had to try to win a second time, and I think your perseverance is inspirational. But what kept you going to say, I'm not going to accept guardianship as the default?
If you don't fight and win and do everything that you need to do for you, nothing gets done.
Well said.
Understand.
Well said. I'll turn to Ranking Member Braun.
I agree. Very well said. My last two questions are going to be for Mr. Parker. In any kind of challenge, when you can get volunteers to help, it spreads the burden. And I was intrigued by the volunteer advocates for seniors or incapacitated adults that now we have 92 counties in Indiana, and this is there in 52 of them. Tell us how that's actually working, and is it a real way to engage folks that are willing to give time, where it looks like in many cases it's hard to find the professional help that hits it on the mark? How's that been working in Indiana?
Thank you. So the Volunteer Advocates Program began around 2014. It was based on things that were happening in the state, but the model was codified in our state law about 10 years ago. So what's really unique about this model is the volunteer aspect. It's important to note who this program is for. So the program is for people who have been determined to need a guardianship and then not having anybody suitable that could serve in that role. That first prong is important here today because these programs are implementing a lot of ways to look at that and say maybe a guardianship is not going to serve the interests of this person. Let's try to find a less restrictive alternative. They're able to directly advocate for those clients and send them to legal services and protection and advocacy organizations. So this has to be for people who absolutely need a guardianship as a last resort option. And then after that, these programs are uniquely situated because you read the statement of Sarah Walker with Southern Indiana Adult Guardianship Services. They're in their local communities. They're working directly with the organizations in their communities, and they are extremely ethical organizations. I'm very impressed. Going around the state, I went on a tour of our programs, and though I knew all of the legal aspects of a guardianship, it was eye-opening to see what these programs are doing to serve the needs of people who truly would have no other options. I've seen this program work in Indiana, and I know that other states are looking at volunteer models, so I look forward to talking with those states about our experiences and potentially having this as an option in other states.
And the last question for me will be in regard to the bill that we're dropping, the Guardianship Grant Flexibility Act. Another way, not only with volunteers, but this would be with law students. And it seems like there's a real interest among them to help, maybe knowing that they're going to engage in this once they get their law degree. So it's a very simple kind of idea. Tell me how you think that will help and if we can get momentum behind it because it's a good idea and that we need it.
So when I was a practitioner, I had the honor of supervising law students at a legal aid society in a variety of areas of law. So I got to see firsthand law students. They're eager to learn, relatively mobile. I mean, Indiana's a large state. They're putting in time on research, and they want to gain experiences that are going to help them in their future legal careers. So I had worked actually with my predecessor in this role to go down to the law school in Bloomington, Indiana, to train a group of students on how to serve their local courts. This was to train them on guardian ad litem work, which is an independent third-party officer, and following a best interest standard to determine if guardianship's even necessary. They're writing reports to the court. And last year, we kind of took that, that solution and took it a step further. When we applied for a grant, we wanted to create a model that links law students to these courts in all different kinds of Indiana communities. There are a lot of issues with workforce and staffing. Courts want to have guardian ad litems. They want to have direct advocates and attorneys serving for people who are at risk of guardianship, but sometimes there's difficulties in recruiting all of the necessary parties into the courtroom. So when we proposed this model, we were hoping that law students could help fill that gap and that in the process they'd gain an appreciation for public interest work and get practical experience. So I think this is an idea that's a perfect example of the type of partnerships that I was talking about. And I look forward to seeking support for such a program in the future.
And thank you for that. And anybody listening out there, get with your respective senators within your states and support that idea, because a lot of times you can take something practical like this, which I think Senator Casey and I try to specialize on, and you got to get others interested in it. And sometimes that's something that can get accomplished in one Congress. And I think this would be a good thing to aspire to. Yield back.
I want to thank Ranking Member Braun, and thanks for the legislation. I think we can have a lot of benefit from having an alliance with law students. They can be great advocates for what we're talking about here today. Well, with that, we'll begin to close, and I do want to again reiterate our thanks to the witnesses for their testimony, bringing your personal experiences here, and indeed your expertise. Today's hearing highlighted both concerns with guardianship, but also solutions. We don't want to just curse the darkness, so to speak. We want to offer solutions. It should be, I think the hearing has showed that there are common sense alternatives to guardianship and the current guardianship system. As Mr. King said, we should not judge people before we know them or their ability to make decisions about their lives. By taking a person-centered approach and creating a supportive, trusted team around that person, we can help people participate in their life decisions and retain their rights and to retain as well their autonomy. To both protect and empower older adults and people with disabilities, a continuum of support should be available to every person. The legislation I've introduced is one strategy to promote that protection and empowerment. I'm grateful for the work of Ranking Member Braun on the legislation we've introduced together. I look forward to working with the committee and our witnesses to find out and implement even more strategies, maybe ideas that we haven't explored today. So I'll turn next to Ranking Member Braun.
Thank you. You know, when you listen to a hearing like this and you hear the story of Dr. Payon and Ryan's story, it's shameful that, you know, in that part of life, when you're going through that issue, that you would have unscrupulous folks get involved and work the system. And I think if there's one responsibility that we have, especially at this level, and even within our own states, is to make sure that does not occur. And I'm really glad that we had this hearing to bring it to this level of attention. It's sad that you need to do that. So I think this is the kind of clarion for everyone out there that's listening and paying attention, and especially within all the states where it looks like we're getting that proper attention. Proud of what we're doing in Indiana, that at this stage of your life, you shouldn't have to be worried about a guardianship that does the exact opposite of what it implies. So glad we had the hearing. I think we accomplished some valuable stuff here, and that hopefully we parlay it through states and here into a better way for those in the future. Thank you.
Thank you, Ranking Member Braun. I appreciate working with you on this and your work on this hearing. So we want to thank again our witnesses, Dr. Payon, Mr. Ryan King, Mr. Nick Parker, and Dr. Sjogren for bringing their wisdom and expertise to help us figure this out. If any senators have additional questions for the witnesses or statements to be added to the record, the hearing record will be kept open for 7 days until next Thursday, April the 6th. So thank you all for participating today, both at the witness table and in the audience. This concludes our hearing.